User Association successfully sued BT, British Telecom, to use CleanFeed, a child porn filter, to block potentially copyright infringing material. And today, there are increased incentives from telecoms operators to promote restrictions where previously they had an interest in openness. Their driver for openness largely had to do with costly implementation of filtering mechanisms and the liability implications and obligations of having knowledge of all of the packets that flow through their networks implied. Until now, these telecom operators didn't have a strong incentive to deploy deep packet inspection beyond the use of securing their networks. But new business models are now being explored, and this is very present in the current debate in the EU on the telecom single market regulation, but also in the United States and actually in several countries around the world. This new business model of prioritizing or tiering or fast lanes and slow lanes means that some services are prioritized over others. This is already more or less happening in several jurisdictions. In Germany, Deutsche Telekom has introduced its own streaming platform called T-Entertain, which is a replacement for YouTube, which they give priority or uncapped data access to. In other countries, such as Spain, telcos have been negotiating commercial deals with online services, such as Spotify or Twitter, to have priority, extra fast, or uncapped access to these specific services. So led by the incentive to consolidate the market, this business model hinges on inspecting each packet as they flow through the network to determine how to prioritize them. Another example of changing incentives is a relatively novel form of online advertising, which relates to the nice story that Chris had mentioned about Form. There is a new way that telcos have been partnering with DPI companies that you probably haven't heard, like Form, to inject advertisements into the network. And as we know from the example from several years ago, but BT continues to test this technology, users are then monitored and profiled without their consent or even knowledge. With these aligned interests of the public and private sectors to monitor, surveil, and filter content, we're at a critical stage for the future of the open and secure internet, and with it, the privacy of our communications. And so I want to look a little bit at the consequences of these aligning interests, and I will highlight three. First is that users should expect constant, total, and indiscriminate intrusion into their communications. The ongoing disclosures on government mass surveillance have revealed the insatiable appetite for the NSA and friends to collect it all, as well as the interest driven by behavioral advertising to collect and build profiles about internet users. The second consequence of these aligning interests is a prevention of users from using anonymizing tools such as encryption. Following these Snowden revelations, users are increasingly turning to encryption as the last line of defense for security. If telecoms operators continue to pursue these new business models, they're likewise motivated to disincentivize the widespread use of encryption, since this inhibits packet inspection. And this is already proven to be the case for some companies, such as a US company called Golden Frog, operating a virtual private network in the US. They have submitted comment to the US FCC to show that Verizon has been actively blocking those VPN connections. And the final consequence is more profiling. With the increase in online monitoring, there would be more and more generation of new personal data, enabling profiling on an even larger scale, as assumptions can be made about you based on data that you didn't even know existed. And so to conclude, privacy advocates and data protection authorities should therefore see net neutrality as a principle that can reinforce privacy online. At this critical time, as the EU is currently debating net neutrality rules, but it is also being debated all around the world, we collectively must ensure the interests of government agencies and some in the private sector to increase monitoring and discrimination do not align. A strong net neutrality law, and particularly clear traffic management rules, would bring transparency to these currently quite opaque traffic management practices. It would also reinforce existing data protection laws by laying down rules of deployment to make sure that the software used to manage traffic is actually used to manage traffic, and that it's targeted, necessary, and proportionate. Thank you.
Regan. Thank you. We're running on time here. Alan has a slightly different perspective that we want to do. To a degree, we've heard some of the doom and gloom that necessarily comes, and Alan's going to provide us with a bit of contrast.
We started off with a very nice, clean definition. I have 3 points. We started off with a nice, clean definition of what is net neutrality, but the reality is it's not the case in the real world. And so I want to talk about some of the surveys and some of the things that are happening under the name network neutrality, because the reality is the public, the consumers, have absolutely no idea what it means. It means something different to everyone, and therefore when consumers have one view of things, they tend to go to their regulators and the legislatures, and all sorts of different things happen than what we might be thinking. The second one is technical. I want to raise a question, and we were just hearing from my colleagues talking about tiering and talking about inspecting data. In today's world, maybe we should. Does it make sense to say certain type of traffic maybe should be slower because it doesn't matter, and certain types of other traffic I want to give priority to? And if you do that, how do you put that in a system that would be manageable from a regulator, manageable from an organization that wants to follow it, and enforceable? And the third one I want to talk about is jurisdiction and enforcement. It's a very hot topic in the United States right now. You've heard it here with, those of us in the privacy space, we always talk about the directive from corporate privacy and those things. We tend not to think quite as much about the e-privacy directive and the telecom acts, but they're really tied together. And just last week, there was an enforcement action that I want to talk about in the US. It took 53 separate government agencies to come together to make this happen. So there's a little glimmer of hope that this could work, but it takes a lot. So let me start. The typical regulator in the United States for communications is the FCC, the Federal Communications Commission. And they have said they want to issue a statement or regulation or something this year on network neutrality. So they put out a call for comments, public comments. It was due July 15th. It broke the internet. Their system went down multiple times in the last 2 or 3 days when everyone submits everything. And at the end of the day, they had to extend the deadline. They had 1.1 million comments come in. And of those million comments, there was an organization that was able to do an analysis on about 800,000. And more than 99% of the people are in favor of network neutrality. Less than 1% are opposed. 200 comments came from law firms representing clients or something. So you can say everyone who wrote, not a representative sample for sure, said this is a good thing. Then they opened up just last month in September a second round. And now the number, which started at 1.1 million, went to 3.7 million comments. It is now, holds the record, it has now surpassed Janet Jackson and her exposed bosom as the number one commented thing in the history of the Federal Communications Commission is network neutrality. The problem with that is, and even the US President Obama, just earlier this month, he's made a statement, I am unequivocally committed to network neutrality. But a recent survey shows more than half the public does not know what that means. It says neutrality has to be good, let's say yes. People really don't understand this. And it reminded me when I was thinking about this, if we go back exactly 50 years to 1964, probably in the United States Supreme Court, the one statement that most everyone in the United States knows, it's the most quoted thing that the Supreme Court ever probably said in a case, that says, I can't define this, but I know it when I see it. And I think that's where we are with net neutrality. Everyone says, if we sat in this room and everyone wrote it down, we'd have 47 different variations of what that means, but we would all agree, is this neutral or not? And you could say yes. And that's a problem. And we'll talk because it becomes an enforcement issue too. The second one is technical. if you think of, and we need to be thinking going forward because the traffic has dramatically changed in the last couple of years, an email or an SMS, it's an asynchronous, it's a one-way communication. I send a message, and if I sent one to everyone in this room, some people will receive it in 10 seconds, some people in a minute, in 2 minutes, in 5 minutes. It really doesn't matter. Downloading a video is uni or single direction. As long as that video shows up 1 second before you need to see it on the screen, it doesn't matter if the thing is there 2 minutes in advance or 1 second, it's the same to you. The one that really matters is voice and video. And carriers have told me more than 150 millisecond, essentially 1/8 of a second delay, and people will start to complain because you can tell in the middle of a sentence, all of a sudden something blocks, and all of a sudden it doesn't sound good, and now I start complaining. And so should we allow, as part of, now, some of my colleagues, when we were talking the other day, said, oh, Alan, that's not network neutrality, that's traffic management. Maybe, I'm not sure. And based on some of the laws that are written that says I cannot analyze a packet, what is that? I don't know the answer, and I'm an attorney, and I'm supposed to be able to tell a client what that means. I don't know. And so I'm asking the question, should there be an allowance for certain types of traffic automatically? Yes, an email can be slower. This type of traffic should be faster. Again, how do I put this into a regulation? How do I enforce this? And from a company who wants to be a good player, how do I operationalize this so I can do it consistently? And the last thing I want to talk about is, as I said, jurisdiction and enforcement. In the U.S., the FCC is the primary primary organization that handles carriers. Just last week, I saw a joint announcement on Friday, I think it was, with Edith Ramirez, whom you've met from the FTC, and her counterpart from the Communications Division, $105 million settlement. And admittedly, this was not a privacy issue per se, although the wording is exactly the same. It was unauthorized charges on consumers' bills. And so the FTC, Edith Ramirez and her organization, is about to oversee refunding consumers $80 million. And this organization has been doing it now many times. They're getting quite good at it. All 50 states and the District of Columbia, that's 51 additional agencies who were part of this investigation, are sharing $20 million to get reimbursed for the cost of the investigation. And the FCC is getting $5 million penalty. And the organization is now having to do an opt-in. Imagine this. So before you're now allowed, this organization's AT&T, it's public, before AT&T can put an extra charge on your bill, the consumer has to take an affirmative action. We call that in privacy world an opt-in. And so just like what we've all done in the business, take away, when you have the tick box that's pre-checked, let's make the check box go away so the consumer has to move the mouse and take an affirmative action, and we can record that at this date and this time from this IP address, that box was ticked and the person said yes. That's how this is working. And I think it's a great example. It's actually the second time this year that the two organizations have worked together. And as you heard from, I believe, Malcolm earlier today on our session, it's time for the enforcement organizations to start working together so it's no longer acceptable to say this is only telecom, this is only privacy, this is only something else, that we must be thinking in a broader way as regulators, as organizations that are trying to do the right thing. Thank you.
Thank you, Alan. Thank you. Now, if I may just ask our hosts, what is the timing that we have for this afternoon? When are we supposed to wrap up this session because we are running late? Excuse me? When are we supposed to finish this session? So we have 5 minutes for questions. And before we go around for questions, does anybody on the panel have a fast remark or riposte, or shall we go straight to questions?
Do you want to go with Reagan and I?
We agree. Chris and I agree. I just wanted to quickly respond to what you had said about traffic management. And this really gets to the point of one of the many myths that perpetuate in the debate on net neutrality is that net neutrality advocates who do not want online discrimination are also against all forms of traffic management. And so everything that you explained, I think that traffic management can absolutely be implemented. Indeed, they need